Uh, We're meeting tonight. We have a variance request. Let me call to order. You go ahead and call the roll.
Chairman Eisenhower,
Here.
Ronald Rensler, not here. Bobby Reynolds,
Here.
Todd Fisher,
Here.
Debbie Powell,
Here.
Bill Mathers,
Here.
and Michael Wesley.
Here.
All right, that's out of the way. I'll entertain a motion to approve the minutes of January 25th, 2021.
So
Our regular
moved.
meeting. All in favor, say aye.
Aye.
Okay. Reports of the committee, members and staff.
No, I don't have anything.
You don't have anything? Old business? Okay, under the new business, we have a variance request, number V 21-02, filed by Enza Pilla. Is that correct? That's close anyway. Property located at 13605 Farrington Oaks Drive, tax parcel number 192-212-56, from section 6.1 building lot standards and dimensions requirements of the Mint Hill Unified Development Ordinance. And anybody that's going to speak on this needs to come up here and be sworn in. Do you swear or affirm that the testimony you're about to give is the truth to the best of your knowledge and belief? So help you God?
Yes, sir. I do.
Okay. All right. You want to go ahead and speak? Yes, go to the podium, state your name and your address for Savannah, so she'll know.
Hi, Richard Garcia, 13605 Farrington Oaks Drive, Mint Hill.
Go ahead.
Okay, I just wrote some stuff down. It's just pretty simple. We just moved down from New York. We moved down in January to Farrington Oaks, which we absolutely love. We had no clue we could not attach a garage for one extra car that we have, and I have a lot of, how do I say, I'm like a painter on the side. So I have a lot of equipment. I have a lot of sprayers. I have ladders. I have stuff like that. I just need stuff for storage. So basically, the way our house is set, if you guys have this paper in front of you, it has a map of the property and the house. If you look at it, the property is set one way, but the lines on the property, the house property itself is set one way, but the property lines are set a different. Because there is kind of like a curve on the side street. So I believe the intentions are 20 feet off the fence line is the law, I guess, for Mint Hill zoning. So at the beginning of the garage, it starts off at 20 feet, and by the time the garage finishes at the back, it's over the line by 4 feet, 11 inches, I believe.
Correct.
So basically, I'm just asking the board to approve my variance as an essential need for my business. I have my neighbor here, Caroline, who would be the only one that it would affect, because I do live on a corner. And the other neighbor would be across the street. He wouldn't even see the garage. So the only one that it would really affect would be Caroline and Scott, her husband, who couldn't make it tonight. That's all I ask.
Okay. Would you like to address the board? Okay, I'll swear you in if you come up here.
Thank you.
Hand on the Bible. Do you swear or affirm that the testimony you're about to give is the truth to the best of your knowledge and belief? So help you God?
I do.
Okay.
Hi, I'm the neighbor, I guess, to the right.
And so it would be, I guess, closer to our property line, but we don't have a problem with it, my husband and I. They've been wonderful neighbors, so we don't have an issue with it. And I know we've got a bunch of trees up the line as well, so I think it will provide plenty of coverage. So we don't have a problem with it. We just wanted the board to know that.
Okay,
Thank you.
thank you. Do you have anything you want to come forward for us?
You guys have any questions?
All right, then we'll go into our facts-finding part of the
We don't
board
get-
here. We got some,
We don't get to ask questions?
yeah.
Okay.
You want to go ahead and ask a question?
Did you bring a site plan showing where the garage is going to go? Okay, so the deck, screen porch was part of the deck? What's this section of the house?
We're enclosing, that's a screened-in porch right now. And so half of it's a screened-in porch and half is open, and that's being enclosed. And this is the new screened-in porch with the new deck.
Okay. I need to pass it down so everyone can see it.
Don't,
Okay.
I'm gonna get, put this up so we can all see it.
I wasn't provided it beforehand, so I don't.
You wasn't? Okay, well, I'm gonna provide it now.
We don't have a way that we can put it straight up on.
Oh, okay.
Just a piece of paper.
Anyway, this is a schematic of the way it's gonna be. And
I have a question for Nathan. So I note that the ordinance does provide for variable side setbacks depending upon lot size. And probably most importantly, it seems to depend on whether there is public water and sewer for the lot, if I'm describing that correctly.
Correct.
So does this lot have public water and sewer? Or
We have public water, we have a septic.
you're on septic, okay. So that would define the 20-foot setback.
Yeah, so it would have the 60 feet in the front and the 20 on
Okay.
the sides.
Okay,
It's on the opposite end of the house.
got it.
It would be on the shingle oak side.
okay, does the other member of the board have any questions to ask?
I do. I'll be honest with you, I've got several. I hope you guys can be patient with me. I've been in real estate 49 years here. And first of all, the actual deed, or the recorded deed says Enza, oh, that's you own it, and you're Richard Garcia. Okay. According to the record, you bought it you closed in November, okay? When you bought it through an agent in our board of realtors, correct? Okay. When you bought it, they are supposed to go through a lot of things with you. When did you discover or not know about, how long was it before you found out about the ordinance?
Yeah, can you get?
Can I just?
Yeah, okay.
Okay.
I thought I was,
You didn't swear
okay,
me
I
in?
didn't swear you, I swore.
Yeah.
Okay. Do you swear or affirm that the testimony you're about to give is the truth to the best of your knowledge and belief, so help you God?
Yes. So
Are
to go to
you,
the-
are you able to speak into
have
the
to
microphone?
Yeah.
for us?
State your name and your address.
Enza Pilla, 13605 Farrington Oaks Drive, Mint Hill. We bought the house when we were looking for a house in Mint Hill, we specifically told my Realtor that we wanted an area, we were looking for certain things, and we wanted if it had one car, we would need to add a garage. We wanted a pool. If it didn't have a pool, we needed to be able to add a pool. She knew that. She did not tell us that there was a 20-foot side setback. The original plans that we drew up and has the architectural seal is for a two-car garage, which would leave a 5-foot, which, between the properties, which would never be approved. So we
Right.
shrunk it down to the smallest that we can go.
Okay. When you bought it, you would have, she was your buyer's agent, correct?
She was.
Okay. You signed a buyer agency agreement
did.
with her? Okay. The reason I'm asking you that is I'm not, in our business, unfortunately, there's a lot of people that don't tell you what you need to know.
Right.
But a lot of it's in writing, and I want to make sure you're aware that it was there. I'm not saying you did know or didn't know, but I want you to just be aware of the fact that there's a lot of things that would indicate you should have known prior to buying the house.
I honestly did not
Okay.
know.
Yeah, what I want to do real quick is, I've got some things I want to show you so that you are at least aware when you sign contracts where it was. I just want you to be aware of it
Okay.
for no other reason.
Okay.
And if you could, Savannah, yeah, I've got 3 sets. I want everybody to have a copy so they know what I'm talking about. There's 3 different sets. And we want you to have a copy too, believe me.
Okay.
The septic will be over there. That's where septic tank will be, right in there.
Thank you, Mike.
It's old water.
Thank you.
Okay, when you bought the property, did you have a survey done on it?
We did.
You did?
I
Okay.
believe we did. We did.
Okay, because I couldn't find anything in the tax records of a recorded survey. That's why I wondered. Okay, let me go through these, and I'm not trying to be difficult. I just want you to be aware of
Yes, I understand,
what you've
sir.
agreed to and signed before, so you know why we might be coming from where we're standing,
Sure.
okay?
Okay.
First of all, the first one I want you to take a look at is the exclusive buyer agency agreement. That should be the first set. Now, do you remember signing a buyer agency agreement with
Yes.
her? Okay. If you look on page 2, or page 3, the next page, you'll see I've highlighted 3 different categories. The last one is buyer acknowledges a sample of a professional services disclosure and election form. That form is the next thing I want to go over because it's, oh, I forgot one other thing. If you go to the next page on the offer to purchase, it's page 5 of a North Carolina real estate contract. You'll see it says buyer or buyer's agents or representatives at buyer's expense shall be entitled to conduct all desired tests, surveys, appraisals, investigations as buyer deems appropriate, including but not limited to the following. And down a little further, I've got the survey as one of those things. But if you go to page 2, or the next page, on page 8 of our contracts, it says owners association in dues. Buyer's agent, representative, closing attorney, or lender should get true and accurate copies of the following items affecting the property. And you'll see it's the declaration and restrictive covenants, rules and regulations, articles of incorporation and bylaws of the Owners Association. You should have gotten copies of that from your agent.
I
And,
don't think-
I know, you didn't get them, and I'll tell you why.
Yeah.
In the listing itself, when I pulled that up,
Mm-hmm.
the only forms that were in there were the seller's disclosure of condition of the house and the mineral and oil rights disclosure.
Right.
Those, what should have been in there is all the bylaws and HOA information, and with it not being there, your agent is responsible to get that information for you prior to you buying the house, doing your due diligence, period.
Right.
Okay, that's North Carolina law. I don't know what it's like in New York, but that's North Carolina law. Now, if you'll look at the second one I've given you, it's called the Professional Services Disclosure and Election. Do you remember seeing this at all?
Which one?
It's called Professional Services Disclosure and Election.
Was it attached to this?
No, it should be the second.
Oh, here it is.
Yeah,
Oh, sorry.
okay.
Okay.
Now, do you remember seeing that when, or did you sign that when you purchased the home? You should have signed it at the time you were writing the contract. And you may not have gotten it, but I'm asking you if you did.
I don't think that I
You
did.
don't think so? Okay.
No. The only thing that I signed was the buyer's agent.
Okay.
And then the next thing I signed was the closing
The,
documents.
yeah, the offer to purchase and everything.
Yeah.
Yeah, that's fine. This is a requirement of the North Carolina Real Estate Commission, and a lot of agents don't do this. But I want you to be aware of what's on that, so you're aware of it. I've highlighted two things. One is with regard to the attorney.
They're both at different angles.
They get you a title exam, title insurance, that
Right.
type of thing. But more importantly, down below it says the survey, okay? And you have choices. You can either waive having the survey, or you elect to have them take care of it.
I believe
and-
we got a survey.
Okay, and if you did, that's great, because
Yeah.
you should have that in your records, but
Yeah.
the attorney did not record it with the deed.
Oh.
Okay? The only survey I could find on your property was the original one done by the builder years ago, McCarr Homes, okay? It's not a big deal, I just want you to be aware of it. Now, the other thing is you've got the picture of the listing information.
Yep.
In the middle, it talks about the HOA and it's mandatory, which is why she should have given you, your agent given you copies of all of this.
Right.
And I'm only bringing it up because when you bought the home, you should have been made aware of all of this. Okay?
But the 20-foot side setback is not the HOA. It's Mint Hill itself.
I
Am
understand that,
correct?
but what I'm
Yeah.
saying is, you should have had access to all of that information in your decision-making,
Oh,
okay? It's-
okay.
yeah,
You know,
it happens
sir,
a lot.
we had her go get a gentleman, a company to go out, make sure that the septic tank, we were doing our due diligence, could be moved if we put the pool here. I mean, we really did do all of that. And I would have,
No, I know you would have done, that's what I'm saying. I'm
Yeah.
not suggesting you knew
no,
and
no,
didn't
no,
do
I
it.
know.
I'm suggesting, we have a business
Of
that I'm
course.
in that
I
we
understand.
have a lot of people that don't do what they're supposed to do.
Right.
And I just want you to be aware of the fact, one of the statements you made is you weren't aware of it, and theoretically, you should have been.
I should have
That's
been.
all I'm saying,
Right.
okay? So those are my questions. I just wanted to
Thank you.
ask you about those.
Okay.
I have another question. Did you look at the option of putting the garage on the back side of the house?
We did, but you can only, in Farrington Oaks, you can only have a 200 square foot,
No, attach it to the house like you're proposing to do.
go back,
You know, you would have extended your driveway down, and then you would have made a left-hand turn into the garage. That would-
attached it, and then
Yeah.
with a cross breezeway or something, attaching it to the house?
Could have-
Oh, you mean going behind the house? I have my pool there.
Okay.
So the option to go behind, like going down and then turning left, is not an option.
So you have the pool in place already?
Yeah.
Okay.
Any more questions from the board? Thank you.
Thank you.
We will now go into part of this, the board goes into like a facts finding, and we ask questions, you know, and not from you, but from each other, and we'll go into that right now. And it takes a little bit of time, not much. I thought there was 4. Yeah, it is 4. Okay. First thing is unnecessary hardships result from the strict application of the ordinance. Ms. Powell.
Okay, I'm going by information that I read on the applicant's application. So I see unnecessary hardships would result from the strict application of the ordinance, as the applicant has no other options to build a garage except as an attached structure, since their HOA rules and covenants limit all accessory structures to 200 square feet.
Mr. Mathers.
I agree with Ms. Powell.
Mr. Fisher.
I'll agree with Ms. Powell.
I also agree with Mrs. Powell. It's the absence of the variance, there's no reasonable use can be made of the property. Mr. Reynolds.
I'm going to agree too. It cannot be used as they intend to use it if we do not grant this.
It's unanimous. I agree with Ms. Powell.
I'll get your name out in a minute. I'm having trouble here. Okay, Mr. Westlake agrees with Ms. Powell. The next one is the hardship results from conditions that are peculiar to the property, such as location, size, or topography. Mr. Westlake.
The hardship is a result of conditions that are peculiar to the property due to the irregular shape of the lot, along with the home placement and the angles that the house was not set parallel to the property line. And with his proposed floor plan, the encroachment into the setback is a minimum one.
Mr. Reynolds.
The hardship does result from conditions that are peculiar to the property due to the shape of the lot.
I agree with Mr. Reynolds. That's Eisenhower. Mr. Fisher.
I agree.
Mr. Mathers.
I agree with Mr. Reynolds.
Ms. Powell.
The hardship results from conditions that are peculiar, specifically being the property line in the house or not being in alignment, causing the rear of the proposed garage to extend over the 20-foot side setback by 4 feet 11 inches.
The hardship did not result from actions taken by the applicant or the property owner. Ms. Powell.
The hardship did not result from actions taken by the applicant. The hardship was created by the placement of the home when it was originally constructed, not being in alignment with the property line.
Mr.
I agree
Mathers.
with Ms. Powell.
Mr. Fisher.
I agree with Ms. Powell.
I also agree with Ms. Powell. Mr. Reynolds.
I'm going to also agree.
Mr. Westlake.
I agree with Ms. Powell.
The requested variance is consistent with the spirit, purpose, and intent of the ordinance, such that public safety is secured and substantial justice is achieved. Mr. Westlake.
The requested variance is consistent with the spirit, purpose, and intent of the ordinance. There's no public safety involved here, and substantial justice would be served by allowing them to build the additional square footage to their house.
Mr. Reynolds.
I'm going to agree with that.
I also agree with that. Mr. Fisher.
I agree.
Mr. Mathers.
I agree.
Ms. Powell.
The requested variance is consistent with the spirit, purpose, and intent. A variance allowing the rear section of the garage to encroach within the 20-foot side setback line by 4 feet 11 inches would allow this homeowner to have an attached garage like other properties within the neighborhood and will have no negative impact on the appearance of the neighborhood.
Okay. I'll entertain a motion.
It's long. Mr. Chairman, regarding variance request V 21-02 filed by Enza Pilla for property located at 13605 Farrington Oaks Drive, being tax parcel number 192-212-56, requesting a variance to section 6.1 building lot standards and dimensional requirements, asking that in addition to her home encroach 4 feet 11 inches into the current required 20 setback. I make a motion to approve, and the reasons set forth in the application justifying the granting of variance for the following reasons. Unnecessary hardships would result from the strict application of the ordinance, and that is reasonable as the applicant has no other options for a garage except as an attached structure, since HOA rules and covenants limit all accessory structures to 200 square feet, and the addition will meet all requirements of section 6.1 except the rear section of the addition. The hardship results from conditions that are peculiar to the property, specifically being the property line and house are out of alignment, causing the proposed garage addition to extend over 20 feet side setback by 4 feet and 11 inches. The hardship did not result from actions taken by the applicant, but results from the placement of the home when it was originally constructed not being in alignment with the property. The variance is a minimum one that will make possible the reasonable use of land and will be consistent with the spirit, purpose, and intent of the ordinance and preserves its spirit. It would have no negative impact on the neighborhood, and public safety will be secure, and it provides substantial justice for the homeowner to have an attached garage like other properties within the neighborhood.
I'll second that.
Okay. We'll take a vote. Mr. Mathis, how you vote?
I agree.
Mr. Fisher?
I agree.
Eisenhower, I agree. Mr. Reynolds?
Yes.
Mr. Westlake?
Agree.
The variance has been approved. It's unanimous. Well, the whole board voted unanimously to approve the motion, which said that approved the variance. So.
I'll move we adjourn.
I second it.
I second that.
Good night.
Oh, before we adjourn, have you set a date for next month yet, Savannah? Okay. Next month, we'll have a training session, and our lawyer, Kevin, will be there. So, if Savannah will send out a memo and let you know the date and whether you can attend or not. And I have an announcement to make when we get there. I'm gone.
We don't want to do it.
Anyway, we have a motion to adjourn and seconded, and we, all in favor say aye.
Aye.
All right.